Swayam Prabha. Digital India. Educated India.
Well, students, my name is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. So, today I am going to discuss role of police in protection of human right. In this lecture, I would like to highlight the role of Indian police in protection of human rights. Police, being important component of criminal justice system, is obliged to protect human rights. And what are those areas where police deviance or police deviates from its statutory behavior and commits custodial violence, and when custodial violence is committed by police, then judiciary takes action and judiciary comes forward to provide rescue, provide remedy to the aggrieved. So, and what are those constitutional provisions which imposes restriction upon police, or what are those statutory provisions under which police officers are bound to follow rules and regulation. So, I will try to highlight some relevant provision of statute and constitution. So, with the help of this slide, I would like to emphasize on role of Indian police in protection of human rights. You see, this is my second lecture of human rights. So, in this second lecture, I would like to highlight role of Indian police in protection of human rights. How Indian police are supposed to abide, supposed to follow rules and regulation prescribed by the statute. And you see, with the help of this slide, I have drawn a clear picture of this Indian police. You see, I have written criminal justice system, and when the moment we use this word criminal justice system, many times students are confused in understanding that which part or which component are considered as essential part of criminal justice system. So, for that reason I have chosen this three important segment areas or three important system which consist criminal justice system. So, one important, you see, the first important component of criminal justice system is police prosecution. Second important component of criminal justice system is judiciary, and third important component of criminal justice system is prison or correctional homes. So, these are important component of criminal justice system. Whenever you all need to understand that whenever criminal justice system word is used, you must understand that the person who is using this word criminal justice system is trying to justify the role of police prosecution, role of judiciary and role of prison. So, how police can play a vital role in protection of human right, how judiciary can play important role in protection of human right, and how prison can play important role in protection of human rights. So, I will try to discuss one by one. So, firstly I would like to discuss role of police in protection of human right. So, how you see how police can play important role, vital role in protection of human right. The first important step where police officer can play important role for protecting of human right, that is registration of FIR, registration of complaint. How registration of complaint or registration of FIR can be helpful in protection of human right. Suppose a person who is a victim of crime, who has lost his brother, sister or father, has come at the police station and police officer is not registering his complaint or FIR. So, at that very moment police officer who is not registering complaint or FIR of that aggrieved is committing, is violating human right of that victim of crime. Victim of crime who is sufferer, who has lost his brother, whose brother or sister or father has been killed, murdered by the offender, by the accused, and police officer has refused to lodge FIR, has refused to lodge complaint. So, can you imagine in that system how police officer can be considered as important government agency to protect human right. So, it is the duty of police to register FIR firstly and then after he should try to start investigation. So, registration of FIR is mandatory, obligatory for the police officer. Non-registration of FIR or complaint would amount to violation of human right of victim of crime. So, this is the first area where human right can be violated or human right can be protected by the police officer. So, you all need to understand these two aspects of role of police officer, how registration of complaint of FIR can be helpful in protecting human rights of victim of crime. So, the second important area, the second important task which police officer can do, and by doing that second important assignment, police officer can play important role in protecting human right of the aggrieved. The second is avoid arbitrary arrest. You see, I have chosen this: police officer should avoid arbitrary arrest, unlawful arrest. Why? Though police officer has power to arrest any person in case of cognizable offence, but police officer by avoiding unlawful arrest, by avoiding arbitrary arrest, can protect human right of that arrested person to whom he should not have arrested. So, after due diligence, after making thorough investigation, after making due investigation, interrogation, then police officer should arrest the person against whom allegations are made. So, by avoiding this arbitrary arrest, by avoiding unlawful arrest, police officer can also play important role. You see, many times you might have seen that police officer, they arrest innocent person, and after arresting innocent person, when person is put before the court and the court, when the moment court declares that arrest detention is unlawful, detention is illegal, at that very moment police officer can be held responsible for violation of human right, violation of that innocent person. On the other hand, innocent person has a right to get compensation from that police officer who has arrested him wrongfully. So, to avoid this arbitrary arrest, unlawful arrest, police officer should make thorough or due inquiry, and then after arrest, if arrest is made by the police officer, then the chances of unlawful arrest, chances of violation of human right would be very minimal, would be very less. So, this is the second important area where police officer can play important role in protection of human right. Third important element is interrogation or investigation, and the fourth important is final report, that is also known as charge sheet. How you see investigation, the third important component, police officer is obliged to investigate the cognizable offence within prescribed time. So, if police officer, investigating officer who is investigating the case is under obligation to complete that investigation within time framework, within time prescribed by the statute. For example, the Code of Criminal Procedure 1973 has prescribed that the police officer has to complete his investigation within 90 days or 60 days. if charge sheet, if investigation is not completed within 90 days, then it would give liberty to the accused to get bail from the court, and accused is entitled to get bail from the court after the expiry of 90 days. So, this 90 days is sufficient time period where investigating officer can complete his investigation. 90 days has been prescribed for those offences which are punishable with death sentence, life imprisonment, or offences which are more punishable with more than 10 years imprisonment. And the offences which are less than 10 years imprisonment, in that case the police officer is under obligation to complete the investigation within 60 days. So, 90 days and 60 days, these two time framework, these two time limitation period has been prescribed by the statute, by the law, by that criminal procedure code, and within this time framework police officer has to complete the investigation. But you might have seen that police officer takes long time to complete his investigation, or many times you might have seen that police officer knowingly or unknowingly they make delay, unreasonable delay in investigating the case, in interrogating the case. There might be several reasons for that: political intervention, political influence. Political reason may one important reason for making unreasonable delay in investigation. So, if investigation is completed by police officer within time limit, time prescribed by the statute, then it would be considered as that police officer has played important role, and police officer has played vital role in respecting the human rights of the victim of crime. Because you see, one important component, every person is presumed to be innocent unless his guilt is proved before the court of law. Accused is presumed to be innocent unless his guilt is proved before the court of law. So, he must be, accused must be presumed innocent unless his guilt is proved before the Supreme Court, not before the High Court, not before the District Court. So, matter will start, you see, criminal matter will start at the District Court, then appeal will be filed by accused in High Court, and then accused will go in Supreme Court, and then because of presumption of innocence, he must be, accused must be presumed innocent unless his guilt is finally proved by the court, by the Supreme Court. He should be innocent, he should be, accused should be considered as innocent. Because of that presumption, our trial system, or you can say that trial court takes time, and then accused get liberty from that statutory provision. He knows that this kind of provision, this kind of law is prevailing in all democratic countries, and that is why he accused takes the benefit, but it is not so in all the cases, depending on the efficacy of investigation. If charge sheet is produced, if investigation is effective, then in that case there is more possibility than accused shall be punished by the court. So, many times it depends upon poor or effective investigation. If investigation is effective, if police has performed his duty effectively and charge sheet is produced before the court, then on the basis of that charge sheet, court can convict the accused. So, investigation is another important area where police officer can, investigating officer can play important role in protection of human right, particularly a victim of crime who is sufferer. And the fourth important thing is final report. Police officer, they are supposed to produce the charge sheet, final report before the competent authority, before the competent court within time, and if final report charge sheet is produced by the police officer within prescribed time, then they can perform their duties as per the statute, as per the statutory requirement. So, these are, now I would like to highlight those statutory provision where police officers are obliged, the police officers are under obligation to start investigation and to complete the investigation within prescribed time. So, you see I have chosen this police as protective agency, this one police as protective agency of human rights. How police can be considered as effective machinery, effective agency for the protection of human rights? The first, registration of FIR complaint, mandatory registration of FIR. You see Supreme Court has to intervene in this case, Lalita Kumari versus State of Uttar Pradesh, AIR 2014 Supreme Court. I will try to discuss important facts of this case, Lalita Kumari case, and avoid arbitrary arrest. I have already highlighted this. By producing accused within 24 hours to the magistrate, Article 22 of the Indian Constitution makes obligation, imposes obligation upon the police officer to produce any accused person within 24 hours before the magistrate. Ground of arrest, whether bailable or non-bailable, it is also specifically provided in the statute, and section 50 talks about information communication regarding ground of arrest. So, I would like to discuss one by one. You see, registration of FIR, mandatory registration of FIR is specifically provided under section 154 of the statute, and the statute, as you all might be knowing, that the name of that statute is the Code of Criminal Procedure 1973, CRPC 1973. It specifically talks about that where information regarding cognizable offence is given to the police officer shall, the word, you see the word shall has been used in that section, section 154. The police officer shall lodge the information, shall register the information, and you see the shall word specifically suggests that police officers are obliged, police officers are under obligation to lodge, to register FIR. They cannot, the word may has not been used, the word shall has been used in the section 154 of the CRPC, and the legislative intention behind putting that provision, behind inserting shall in that section is police officer cannot deny to register FIR. But many times you might have seen that the victim of crime has to approach police station and being aggrieved, the victim of crime, the same victim of crime has to knock the door of SSP or SP, the same victim of crime has to knock the door of DIG, DGP of the state, and even though being aggrieved, that victim of crime has to knock the door of High Court only for registration of FIR. And in exceptional cases, it has also been seen that Supreme Court, even victim of crime has to approach the Supreme Court, and by you see Supreme Court, it has been also you all might be knowing the case where Supreme Court directed the state government to lodge FIR in a particular case, because FIR was not lodged in that particular case, and that is why victim knocked the door of Supreme Court just for what? Just for the registration of FIR. So, this is the plight of victim of crime, and this is the ground reality of this. But though there are exceptional circumstances, exceptional cases where victim of crime has approached the Supreme Court for registration of FIR. In spite of statutory provision, it is specifically mentioned in section 154 CRPC that registration of FIR is mandatory. In this Lalita Kumari case, what happened, as you all might be knowing that facts of this case, I just want to quickly highlight the facts of this case. What happened in this Lalita Kumari case, a minor girl was abducted by the accused from the guardianship of her parents. So, at the time of abduction, she was minor. When the father of Lalita Kumari went to the police station for lodging FIR, for registration of FIR, police officer refused to lodge FIR. Being aggrieved, he approached the superintendent of police, and where he wanted to give information about missing of his minor daughter. But you see, police officer also refused to lodge FIR, and then you see how whereabout of that minor girl was not known to the father. So, being aggrieved, he went to the SSP of that area, and with the intervention of SSP, FIR ultimately FIR was lodged. But the FIR was lodged, but in spite of that, police did not start investigation. So, again he went to he knocked the door of superior authority for arresting the accused and to start the investigation in that case, but police officer refused to start the investigation. You see the plight. Then when this matter came before the Supreme Court, for what? Just to make interpretation of section 154 CRPC, whether registration of FIR is mandatory or not. Police officers are obliged or under obligation to register FIR or not, the first question. And second question was whether if application regarding cognizable offence is given by any person to the police, and that application discloses that cognizable offence has been committed. So, police officer must register FIR, or police officer should make a preliminary inquiry in that case. After making inquiry, then police officer should lodge FIR, and police officer should arrest the person against whom allegations are made. So, in this case, what Supreme Court held? Supreme Court held that where information, where application by any aggrieved victim of crime is given to the police officers are under obligation to register the FIR. Mandatory registration of FIR was recognized in this case. Supreme Court directed that it is the legal duty of each and every station head officer, police officer to register FIR. The moment he receives an application which reveals that cognizable offence has been committed by someone, at that very moment it is the legal duty of police officer to lodge FIR, mandatory registration of FIR. And second important case is that it is not discretion of the police officer whether to start investigation or not. Police officer will have to start the investigation. Police officer is under obligation to start the investigation in cognizable case. So, you see this judicial pronouncement made it clear that mandatory registration of FIR is valid. Section 154 CRPC imposes statutory obligation upon police officers to lodge FIR. They cannot deny, they cannot refuse to lodge FIR. This is the first important case where Supreme Court has issued various guidelines for registration, mandatory registration of FIR, which is important for you at this time. So, the things which are important for you at this time, only I am trying to highlight only those important areas. The second important thing is you see how police officers can play important role in protection of human right by producing accused within 24 hours from the time of arrest. If arrested person is produced within 24 hours from the time of arrest, it would be considered as paying due respect to the Constitution. Constitution of India, being supreme law of the land, makes obligation upon police officer to produce any arrested person before the magistrate within 24 hours from the time of arrest. Why this provision was inserted in the constitution, supreme law of the land? Because our constitution makers were very much aware about the working of police or functioning of police, so that police officer cannot misuse their power, cannot deviate from their statutory behavior. So, our constitution maker deliberately put this provision in the constitution as a fundamental right in the part 3rd of the Indian constitution. So, how you see, every arrested person has fundamental right to be produced before the magistrate within 24 hours from the time of arrest. So, it would be helpful in protecting the human right of the arrested person. This provision is helpful in to avoid police atrocities. Police may commit atrocity or any kind of violence to the accused. So, in order to avoid police atrocities, in order to avoid police custodial violence, this provision is inserted in the constitution that every arrested person has fundamental right to be produced to the judicial magistrate, to the magistrate, nearest magistrate within 24 hours from the time of arrest. At least the information regarding arrest should be given to the judiciary, should be given to the court. Court may be in position to be aware about those persons who have been arrested by the police in his area, in that area where offence has been committed. So, the purpose of Article 22 of the Constitution is just to give information to the court that how many persons have been arrested by the police officer in that particular jurisdiction, in that particular area, and this is the first purpose. The second important purpose of this constitutional provision is that just to avoid police atrocity. If information is given to the judiciary, then police officer will think twice to commit any kind of police atrocity in the name of interrogation, which frequently happens in custody, in police custody. So, this is the purpose of Article 22, that every arrested person has fundamental right to be produced before the magistrate within 24 hours from the time of arrest. This is the constitutional mandate which must be followed by the police officer, and if police officer has failed to follow this constitutional mandate, the custody, the detention would be unconstitutional. And if court declares that detention unconstitutional, that innocent person has right to get compensation from the state, as well as the police officer being a culprit can be prosecuted and convicted for wrongful confinement under section 340 of the Indian Penal Code. The police officer can also be prosecuted for making a wrongful confinement. So, this is the consequences of unlawful detention, unlawful custody. Second important area where police can play important role in protection of human right, by giving information to the accused that accused has committed bailable offence or non-serious crime. So, section 50 of the CRPC, it is specifically mentioned in section 50 of the statute CRPC 1973 that it is the duty of police officer to communicate the accused about nature of offence, what offence he has committed, whether offence is of serious nature or of petty nature. It is the legal duty of police officer to communicate the accused whether offence is bailable or non-bailable. If offence is bailable, non-serious in nature, and accused is ready to furnish bail bond to the police officer is under obligation to release that accused on bail. So, you see, refusal from grant of bail to the accused, where accused has committed petty offence, non-serious crime. So, refusal from grant of bail would also amount to violation of human right of that accused, because it is specifically written in the statute that in case of non-serious crime, accused shall be released on bail. So, shall word has been used in that section, and shall, you all might be knowing that may word and shall word, these two words have a specific meaning. So, shall only means that the grant of bail is mandatory where accused has committed non-serious crime, offences which are punishable with less than 3 years imprisonment. In that case, police officer is obliged to, is under obligation to release the accused on bail. So, this this is another area where police can play important role in protection of human right, and these are certain things which I have tried to explain. Now, come to this another slide, that is investigation. You see, I have highlighted two important provision. When evidence is not sufficient, then what police will do? When evidence is not sufficient, then closure report is filed by police investigating officer, by IO, under section 169. So, 169 of the CRPC empowers the investigating officer that in case of inadequate evidences, where evidences are not sufficient, then it shall be lawful for the investigating officer to close the matter, and closure report is filed in that very court in whose jurisdiction that offence has been committed. So, closure report may be filed by the police officer, and if police officer is of investigating officer particularly is of the opinion that cognizable offence has been committed, in that case under section 173(2)(1), police investigating officer has to file charge sheet, has to file police report in that very court in whose jurisdiction offence was committed. So, NCR, you all might be knowing that I have also written this word NCR, non-cognizable report. Police cannot start investigation in NCR unless directed by the magistrate, meaning thereby in case of non-cognizable offence, no police officer can start investigation unless he is directed by the magistrate to start the investigation, because non-cognizable cases are not more serious crime in nature. So, that is why unless investigation is directed by the magistrate, police officer, investigating officer cannot start the investigation and cannot arrest the accused against whom allegations or applications are made that accused has committed non-cognizable crime, non-serious crime, and non-serious crime or serious crime, as I have already highlighted in my previous lecture, that on the basis of gravity of crime, the statute has made distinction between serious, more serious crime or less serious crime, heinous crime or non-serious crime, that is cognizable offence and non-cognizable offence. Specific words are used. So, you see, unless investigating officer is directed by the magistrate, he cannot start investigation in non-cognizable offences. Now, come to this constitutional and statutory safeguards. This slide will make it clear that there are certain provision in the constitution as well as in the statute where human rights of the accused are specifically protected. So, you see how article 20 clause 3 on this, you just look at this slide. Article 20 clause 3 talks about protection against self incrimination. Article 22 talks about legal representation on free legal aid, protection within 24 hours, section 24, 25, 26 of Indian Evidence Act 1870. So, I have classified these safeguards in two categories: constitutional safeguards and statutory safeguards. Constitutional safeguards article 20 clause 3, 22 and statutory safeguards section 24, 25, 26 Indian Evidence Act. So, let us discuss one by one. Now, come to this article 20 clause 3. How article 20 clause 3 is helpful in protecting human rights of the detained arrested person. Article 20 clause 3 talks about protection against self incrimination. So, article 20 clause 3 says that no person shall be compelled to be a witness against himself. So, this kind of protection is a fundamental right. If any investigating officer is putting pressure on any accused to confess his guilt, it would be violation of his fundamental right. So, this kind of protection, you see, this kind of protection is deliberately inserted under article 20 clause 3, and our constitution makers, they were very much aware about the rights of innocent person. So, because of that apprehension, our constitution makers, they put this provision in part 3rd of the Indian constitution. They put it as they considered it as important as human rights, as a fundamental right. So, article 20 clause 3, it protects an innocent person not to be compelled, not to be accepted his guilt against his desire, against his will. So, if any investigating officer is compelling, has put pressure upon the accused to confess his guilt, it would be violation of his fundamental right, and that accused can directly go to the Supreme Court or High Court on the ground of that statement that investigating officer at the time of interrogation was compelling to accept that crime, and then the entire practice, the entire procedure, the entire exercise of that investigating officer would become futile, would be futile, and court may pass order against that investigating officer that this IO should be changed, because he has breached the law and he was compelling, he was putting pressure upon that accused. So, there might be several consequences for non-compliance of article 20 clause 3. So, now come to second article 22, which is directly connected with fundamental rights of the arrested person, article 22 of the constitution. Article 22 talks about that every arrested person shall be produced to the nearest magistrate within 24 hours from the time of arrest. So, this kind of provision may also be helpful in protecting the human rights of innocent persons. Right to free legal aid, right to legal representation. Article 22 of the Indian constitution also talks about that every arrested person has right to have counsel of his own choice. So, right to be represented legally, right to be represented by counsel, right to have counsel, that is also a fundamental right guaranteed by article 22 of the Indian constitution. So, article 22, right to have counsel at the time of interrogation, right to get legal assistance of his own choice. So, every arrested person is free to have a counsel, to engage an advocate, to engage a counsel of his own choice, not at the time of trial, but right from the investigation till the completion of trial. So, you all need to remember that this fundamental right is available right from the interrogation until the completion of trial. So, this is another important protection, and you all might be knowing that right to free legal aid. If accused is poor, indigent, then he is also entitled to get legal assistance on the cost of the government. It is the constitutional obligation of state to provide free legal aid to that arrested person. It is specifically provided under Article 21 of the Indian Constitution, and this right to free legal aid has been recognized by Supreme Court as essential component of right to life and personal liberty. In MS Horscott versus State of Maharashtra, AIR 1979, Supreme Court, which I would like to discuss in coming session. Now, come to statutory safeguards. What are the statutory provisions which provides protection, which talks about special safeguards to the accused, to the innocent person? As I said, every person must be presumed to be innocent unless his guilt is proved before the court of law. So, because of that presumption, every arrested person has right to be tried fairly, to be interrogated fairly. So, section 24, 25, 26, these three important provision of Indian Evidence Act 1872 are also helpful in criminal justice system. How? Section 24 of the Indian Evidence Act 1872 talks about threat inducement. No threat or inducement shall be given by the police officer during the investigation. So, you see how confession, if any confessional statement is obtained by investigating officer due to threat, due to inducement, then that confessional statement will have no legal significance, will not be considered as piece of evidence according to this statute, because that statement is not free from that statement is not voluntary, that statement that confessional statement has been obtained by investigating officer by putting pressure upon the accused or due to inducement, any kind of inducement. So, section 24 prohibits such kind of statement. 25, section 25 is also relevant in this regard. Section 25 of this Indian Evidence Act 1872 says that confession made to the police officer is irrelevant, cannot be considered as a piece of evidence. So, if any accused who has confessed his guilt to the police officer that he has committed murder, suppose in case of murder, if an accused person has confessed his guilt to the police officer that he has committed this murder. So, this kind of statement would not be considered as a piece of evidence in court of law. Section 25 makes it clear. Section 26 of this statute talks about confession in police custody. 25 confession to the police officer, and section 26 confession in police custody, that is also irrelevant, cannot be considered as a piece of evidence. So, you see how why these safeguards have been given in statute. The reason behind not accepting confessional statement as a piece of evidence is that if it would have been, you can imagine that if it would have been recognized in law, then can you imagine that working or functioning of police officer can prosecute, can arrest any innocent person, and just by putting pressure on that accused, police officer can easily obtain confessional statement, knowing that this confessional statement would be considered as piece of evidence, and on that basis he would be successful in completing that investigation, and he would be successful in convicting, in prosecuting any innocent person. So, deliberately this kind of provision was put in statute, and because of this statutory safeguards, police officer cannot obtain any kind of statement which comes within ambit of these statutory provisions. So, I think that you all have understood all these things. Now, other safeguards you can just see other safeguards, section 163, 164 CRPC You see, section 164 is very important here. It is pertinent to mention this section 164 CRPC, judicial, which talks about judicial confession and other statement, and section 330 IPC, 323 IPC, causing hurt at the time of investigation, and confinement, wrongful confinement. It would create a problem for the police officer, where police officer, investigating officer, they wrongfully confine any accused. It would create problem for them, not for the accused, but it would be problematic for the police officer, investigating officer, where they have wrongfully confined any accused. So, now let us discuss one by one how 164 is important, and 164, let us 164 CRPC talks about judicial confession, where accused has confessed his guilt before the magistrate. That confession is very important piece of evidence. This is one aspect of judicial confession, and section 164 also gives liberty to the magistrate to record any kind of statement from the aggrieved, where victim of crime himself or herself has come before the court to record his or her statement, so that police officer cannot manipulate or fabricate statement at the time of investigation. Then if statement is recorded by judicial magistrate from the accused or from any other person. So, other person here also, other person may include victim of crime. So, where victim of crime has apprehension that police officer can manipulate, can fabricate the entire story, then victim of crime may knock the door of magistrate, that if her statement would be recorded by magistrate, if statement of victim of crime would be recorded by magistrate, then there would be no chance, no possibility for manipulation or fabrication, because judiciary, because magistrate is part of judiciary. So, whatever he will do, magistrate will do, that is done in the interest of justice. So, because of this presumption, the statement recorded by magistrate under section 164 has great value in eye of law. So, you might have seen that in most of the cases where victim of crime is educated or literate, so they prefer to record their statement to the magistrate. Soon after giving their statement to the police officer, they try to record their statement to the magistrate, because in case of contradiction between police statement and statement recorded by magistrate will be given more preference. So, because of this reason 164 is very important, and I have already highlighted section 3, wrongful confinement and grievous hurt. If grievous hurt is caused, police atrocity is committed by police at the time of interrogation, grievous hurt is caused, simple hurt or grievous hurt is caused by police officer at the time of interrogation. You must understand this. Even police officer, investigating officer can also be prosecuted for committing assault or hurt, grievous hurt to the accused. So, this is a very. So, in order to now come to this another aspect of human rights, where police officers, they have been warned, they have been given direction by the Supreme Court not to violate, not to commit atrocity. So, there are two important case laws to which I would like to highlight. First case is D.K. Basu versus State of West Bengal, AIR 1997 Supreme Court, and second important case is Arnesh Kumar versus State of Bihar, AIR 2014 Supreme Court. So, as you all might be knowing that in my previous lecture, when I was talking about criminal law, in that lecture I highlighted these two important case laws, D.K. Basu case and Arnesh Kumar case. So, I do not want to go into the technicality of these two cases, but quickly I would like to highlight these two important case laws, because these two important cases are very important at this time. In D.K. Basu case, what happened? D.K. Basu case, Supreme Court has already issued various guidelines for the protection of human rights. So, police officers at the time of arrest, they will ensure that the arrested person should be produced within 24 hours, arrested person must be informed the ground of arrest, whether offence is bailable or not bailable. Arrest memo, important thing is, two things are important at this time. This is the arrest, preparation of arrest memo and discovery memo. So, whatever things are done by police officer, investigating officer at the time of arrest, arrest memo must be prepared. A report, a comprehensive report regarding arrest must be prepared by investigating officer. In that arrest memo, the name of accused, nature of offence, time and place of arrest, the two witnesses of that place from where person has been arrested, then their names and details must be mentioned. Discovery memo, what articles, what weapons, what kind of weapons have been discovered. Discovery memo, discovery report, report here means memo. Discovery memo must be prepared by investigating officer. Second important case is that I have already highlighted in previous lecture, Arnesh Kumar versus State of Bihar. So, Supreme Court has specifically categorically held that no arrest shall be made by police officer where offence is punishable up to 7 years imprisonment. So, only this thing is important. What happened in this case, that is not relevant at this time. The only thing is which you need to remember in this lecture, that is police officer has been warned, has been directed by the police, by the Supreme Court, that no police officer in this country shall arrest any accused who has committed an offence which is punishable up to 7 years imprisonment. So, this you need to remember this thing. Now, come to this another aspect of human right issues. What are the issues, human right issues and problems, challenges, and police, how police are playing important role. So, as I have categorized these three important areas. I have chosen these three important areas where police officers are under obligation to ensure this. Arrest how made, fake encounter. So, arrest how made, manner of arrest, this is specifically provided under section 46 of this statute. In order to avoid fake encounter, preventive detention, police officers are empowered to arrest any person though where offence has not been committed. So, that detention is known as preventive detention. In order to avoid commission of cognizable offence, police officer has power to arrest any person before the commission of crime. So, that the police officer should take care while arresting any person. Under section 151, police officer can arrest. Section 41. Section 41 gives wide discretion to the police officer to arrest any person where a person has committed cognizable offence. Now, rights of the accused. So, this is very important slide for you all, because the rights of the accused is very important. So, I have tried to put all the relevant rights of accused in one slide. You can see right to bail. Article 436, quickly I would like to highlight a right to bail. Every arrested person has right to be released on bail, though this provision is specifically provided under section 436 of the CRPC, Criminal Procedure Code, that every arrested person who has committed bailable offence, this is subject to, you see, right to bail. This is statutory right, legal right, but that is subject to the nature of offence. If offence is relating to bailable offence less than 3 years imprisonment, in that case arrested person shall be released on bail. So, that is right, that is legal right, and he can claim that right as a matter of right. He can claim that protection as a matter of right, right to bail. Right to be informed, ground of arrest, section 50, article 22, you could just article 50 CRPC, article 22, right to be informed, the ground of arrest. Third important right is right to be examined by medical practitioner. Section 54 CRPC talks about right to medical examination, right to medical aid, right to be examined by medical practitioner. So, you all might be knowing that there are two important provisions, section 53 and 54. Section 53 gives liberty to the police officer. Police officer soon after the making arrest has power to examine the accused by medical practitioner. So, that kind of protection is given to the police officer. That is a kind of shield protection provided to the police officer, so that accused cannot raise any objection against the police officer, that at the time of police arrest police officer has committed atrocity against the accused. So, in police officer in their own defense they can examine the accused from medical practitioner, and as well as arrested person has right to be examined by medical practitioner, so that he can produce the injury report before the court, that at the time of arrest he was healthy and during interrogation he got injury, he sustained injury by police committed violence in custody. So, for that protection article section 54 of CRPC, right to compensation, you just see right to compensation, Bhim Singh versus State of Jammu Kashmir, Ruddal Shah versus State of Bihar. So, right to compensation is also important right available to an innocent arrested person. Arrested person who has been arrested by the police officer, the moment his custody, the moment his arrest is declared unlawful by the court, after obtaining that order from the court that his detention arrest was unlawful, he can get compensation from the court, he can get compensation from the state government, he can get compensation from the police officer who has arrested him wrongfully. So, this is also important, right, where these two, you see, you need to remember these two important cases, Bhim Singh versus State of Jammu and Kashmir, Ruddal Shah versus State of Bihar, and the fourth important right is right to have a counsel. Article 22, as I said, every arrested person has right to engage his counsel of his own choice. Every arrested person has right to get legal assistance from the state if that arrested person is not in position to engage his counsel on his own cost, or he is not in position to pay court fee, he is not in position to pay advocate fee, counsel fee, on account of poverty, he is poor, indigent. In that situation, that arrested person has right to get free legal aid, free legal assistance from the state. So, because the only reason of that provision is every person is presumed to be innocent unless his guilt is proved. So, unless his guilt is proved before the court of law, he is innocent. So, because of that presumption, arrested person has right to get free legal aid from the court. So, right to have a counsel and right to have a free legal aid, right to get free legal aid, these two important precious rights are also available to the arrested person. So, these are some these are few important rights which accused can avail from the state, and I think that whatever point has been discussed in this lecture, assuming that you all must have understood the role of police in protection of human rights. I have already highlighted constitutional safeguards as well as statutory safeguards in protection of human rights, and the role of Supreme Court, where Supreme Court has issued various guidelines for the police officer to respect those. By respecting those guidelines, police can also play a vital role in protection of human rights. So, in this way we have seen that Indian police can play important role in protection of human rights in the light of constitutional provision as well as in the light of statutory provision by respecting Constitution, by paying due respect to the supreme law of the land Constitution, by paying due respect to the statute and by paying due respect to the Supreme Court, police officer can play important role in protection of human rights. So, with this I would like to conclude this lecture, and I hope that I do believe that you all have understood the things which I have discussed in this lecture. So, with this I would like to thank you all. Thank you very much.